competition will be the finals that will be adjudicated by the Supreme Court judges, and this year enriched by the presence of the international juries, as I have indicated. As the registrar of the court, I urge all the participants to seize the opportunity. Each year brings new themes, more dynamic and more prospering. Take full advantage of the intellectual resources offered by both the MOOT court judges and the Supreme Court bench. A bright future awaits you in your journey, whether at the bar or in the bench. I extend a special recognition to our partners and sponsors. In particular, we have been sponsored by INDLO to support the MOOT court this year. INDLO has been steadfast in the support alongside the association, the International Association of Refugee and Migration Judges. With such partnerships, the competition can only grow bigger and better. Indeed, in the years ahead, we envision transforming into a continental MOOT court series, positioning the Supreme Court of Kenya at the forefront of legal mentorship in Africa. Finally, I wish every team success as you showcase your legal prowess and passion for this noble profession. May this competition ignite in you a lifelong commitment to justice, service, and excellence. The future of the bench and the bar shines brighter because of you. I wish you all the best. May God bless you. And even those who may not make it to the finals, we have the award ceremony on Friday. So please be present, witness your colleagues, cheer them on. May God bless you all. Thank you. I declare the MOOT court competition open. Thank you.
Principal Magistrate. Then we have a bench sitting in Court of Appeal, courtroom number 3, and that bench constitutes of Honorable Anne Nyoike, Senior Principal Magistrate, Honorable Alice Mukenga, who is the one speaking, and then Honorable Hosea Nganga, Principal Magistrate.
you, Honorable Mukenga. Okay, let's calm down. Those who are talking, Henry. Okay. So as you have been told, I'm Walter Kobe. So I'll just give you a few instructions, if I can call them so, that will guide you over the next three days. So today will be the preliminary rounds. Then tomorrow, Thursday, we'll have the quarterfinals and the semifinals. Then Friday we have the finals and the award ceremony. So today, after the sessions, in the evening we will all gather back here for the results of the preliminary rounds. That result will be one representative to come. One, yeah? Yes. Yes. Riara. Oh, you okay then. You are the one we are. I think you are the one we are looking for. But let me just confirm. Riara, Moi, Mount Kenya, Maseno, Kenyatta University, Kabarak, JKUAT, Embu, Egerton, Daystar, Chuka, Catholic, African Nazarene, Uma. Yeah, I think it was Riara that we are looking for. So you are all here. Yeah, so we'll just start from here. So you come and pick, then we have the secretarial which will record what you have picked, yeah?
So, okay, I want somebody to confirm these boxes.
Yes.
Also, this is us. He has confirmed there are 16. Once you pick your article, you just pick one. Then when you pick, you register what you have taken. Then from there, you know which courtroom you go to.
So we'll start from you. Okay, yeah. So, yeah, you come. So you don't say your university, you say your team code, yeah? You tell her to record your team code. I hope you remember your team code, the one you use for the memorials, yeah? So I should have reminded you about that, yeah? Always remember your team code, team code, team code. That's your identification throughout the 3 days. So once you have recorded here, then you can go sit. All the team code. Okay. You can talk to your. It's okay. Talk to your. Hope you remember your team code. Yeah. Okay. Just confirm. Let him confirm.
SG09, you'll be in court 3 and you'll be an applicant at 10. Yes. 5A. 5A, you'll be in court 3
Need her urgently. The person who picked that barrels.
You see? Ben?
12,
Yes.
12 artisan
Annual
that you
Supreme
said you're
Court
number
competition.
10, code 10,
Welcome.
SC010. Okay.
To the annual Supreme
In
Court
order, so you will be in
competition.
court 2 and you will be a respondent and you will be the round starting at 10.
To be a trusted apex court that protects the Constitution, sovereignty
Yes,
of the people of
respondent.
Kenya,
Yes.
rule of
yes,
law,
yes.
and
You see, R
enhances
is for respondent.
jurisprudence.
Yes, court number
Ben.
2. Okay. Yes.
Niambie tu. Tena. Niongee.
Oh, this is the lady,
No, one she's the one who picked one head. You see, the lady picked the first one, but she did not pick number 1.
what is your code? And you picked 1A. You're in the same school as her?
No. She was the first to pick, but she didn't pick number 1.
So you'll be in court 2 and you'll be an applicant.
Tunasemaje iko sawa?
Round starting at 10.
Ndio tusikie sasa. Easy.
Wacha tumalize.
So fingerprinting.
14 are
Okay.
what's your
Annual Supreme Court competition.
C0?
The court derives its mandate from the Constitution and exercises the following jurisdiction.
A respondent.
Exclusive original jurisdiction under Article 163, 3A to hear and determine disputes relating to the elections to the office of the President. In exercise of the jurisdiction, the court iko sawa. The sound card hapo sawa. Wanaume bana, alafu mtu anataka 2000 shillings urgently.
Wekea askari wako kiti hapa. Kila koti iko na askari mmoja.
Kiti mtatoa wapi space? Assistant nani? Kuna uko na protocol.
Okay, attention. As you remember, we'll have the first round where maybe if you are an applicant, then the next round you will be a respondent, yeah? So we are still just computing everything so that we give you a comprehensive announcement of the court you will be in first round, and then the court you will be in the second round. But even as we compute that, I just want to make an announcement. So at around at around 11, we'll have tea break, and at that tea break, the students, the tea will be set up somewhere here, just next to the corridor here. So you'll come here and you'll find a setup where you'll take tea. The same with the lunchtime. At lunchtime also, you'll come just near the corridor, just near this door. You'll also find a setup for lunch, so you'll have lunch. Yeah. So that's for the 3 days. Then the coaches and the faculty that are here. So you are set up. You'll just ask from the protocol team. There's what's known as boardroom 74. So coaches and faculty members from the various faculties that are here, you'll ask to be directed to boardroom 74. The last announcement I want to make, remember we have said that we don't want the judges to identify your universities, yeah? So we have noticed there a few of you have, what do I call it, the pins, lapels, yeah? That have your universities on whatever. So please, just for these 3 days, yeah? Just don't have them on, yeah? Because when you wear them, the judges will be able to tell that I'm assessing a team from Strathmore or wherever it is, yeah? So please, we're just requesting you don't have them on so that you are not identified by your school. We only want you to be identified by the number. So we saw earlier on some confusion where some teams were saying something which is not the accurate team number. So always remember that number. Thank you. So wait a few minutes, then we'll announce the comprehensive list of where you will be at a particular time.
Mimi nimerelax, nilisema mnipe library nipate muscles. Tunasema folder gani imechukuliwa? Acha itengenezwe. Peter, judges wako huko? Na kama niko huko code 4 tunamalizia na kuja. No problem. Ati? Yes. Pole. Lakini relax. Kuna kacheza kwa sababu amesema si wakimaliza YouTube the students huko alafu twende library kwa hiyo. Sasa mimi napeleka wapi? Kongoja hapo nje. Wanangoja hapo nje. Si wengi ni wangapi wa hiyo? Sisi ni students sita. Shikira shule watatu. Shule watatu. Sasa unajua mtaanza mbele yangu. Tunaanza kwa mic kama iko. Nimesikia tukisema ukiomba vitu.
Okay, so we have the result of the casting of lots, yeah? So I want you to be very keen, yeah? Please, those who are speaking, so that we are clear. So court 1, SC012 will be applicant. This first round, SC012 will meet SC011, yeah? So they'll be in court 1. So if you are 12, you'll be applicant, 11 will be respondent in court 1. So note that, court 1, this first round. So for court 2, SC04. So if you are SC04, okay, we'll tell you the courts after this announcement, yeah? So court 2, SC04 will be applicant and SC01 will be respondent in court 2. So note that. Court 3, SC08 will be applicant, SC013 will be respondent at court 3. Then SC06 will be applicant, they'll meet SC02 at court 4. So those are the first 8 teams. I hope you have got. So those are the first 8 teams that when you leave here, those people, those teams that I've announced, you go straight to the court. Then after that set, the next set of 8 will be SC016 will be applicant. They'll meet SC07 respondent before court 1. Then court 2, SC014 applicant will meet SC010 respondent before court 2. Then court 3, SC09 applicant will meet SC018 before court 3. Then SC05 will meet SC015. So SC05 will be applicant, 015 will be respondent before court 4. I'm sure up to that you will have all done the first round. So after that first round, we go to the next round. So in the next round, SC010 will now be respondent, and they'll meet SC04, who will be applicant. They'll now go before court 1. Then court 2, SC07 will now be applicant, and they'll meet SC012 as respondent before court 2. Then court 3, SC01 will now be applicant. They'll meet SC014 as respondent before court 3. Then SC011 will meet SC016 as respondent. 11 as applicant, 16 as respondent before court 4. Then the last round, now the last 8 will now be SC015 as applicant, meeting 06 as respondent before court 1. Then SC018 will meet SC08 as respondent before court 2. Then 02 as applicant will meet 05 as respondent before court 3. Then the lastly, 013 as applicant will meet 09 as respondent before court 4. I'm sure each team now knows where they'll be as either applicant or respondent. I'm sure it's clear. So the next thing that I'll do, I'll invite Alex to tell you where these courts are. But even if you get confused, just ask any of the protocol officers to direct to where these courts are. So just note which court you are appearing before and where you'll be told where it is. And before I allow Alex, let me also announce something. So those of you, when the 8 are mooting, there are the 8 teams that will not be mooting at that particular time. We have benches here next to this sort of like garden here. So you can sit here. Then at the library up, second floor, also outside there, there are also a set of benches. So you can also, some people can also sit there so that as you wait for your turn. So let me invite Alex to indicate to you where the courts are.
Yeah, good morning. For the purposes of the mooting, court number 1 will be at the library. Use the main corridor up first floor. Goja kidogo tusifanye commotion. This will be a court assistant, Esterina. So in court 1, you will meet Esterina, be your court assistant. Court number 2 will be where we are sitting. It's referred to as Supreme Court number 4. Your court assistant will be Jane. Court number 3 will be Court of Appeal, room 3. The court assistant will be Brian. Court number 4 will be up first floor on the far end. It's Court of Appeal number 4, sorry, and I will be your court assistant. So at this time, we take a few minutes, then after this discussion is over, we will move to the specific courts. And the people using this court, this door is reserved for the judges. All other people are supposed to use this back door. And I hope you have been told when the other teams are mooting, you are not supposed to be inside the courtroom where the mooting is happening. Yeah?
So thanks. I think we are done. We have clear guidance on, but even I've seen a few who didn't get correctly where they are supposed to be. So if you really want a clarification, you can just come. You clarify where you are supposed to be. But let me allow care. So I'm just reminded, so we'll just work it tentatively at around 4, we'll gather back here, yeah, as I announced earlier, so that we know the results of the preliminary round. So at around 4, we are hoping we'll be done by then, and then the team that is doing the computation for the marks will also be done. So we gather here so that we get a briefing on what those who are going to the next stage tomorrow. Yeah, in case of anything, just come for clarification. But now, I think at this stage, you are free now to leave. To the first 8 that are announced, you leave and go to the courts. Yeah, you can follow in fact, you can follow. I'm sure you have been told the assistant. So just follow them so that they guide you. You go with them. The judges are already there. The rest wait outside here. If you want clarification, you just come.
Honorable Kasavuli will be presiding over the session. I will now welcome the judge to introduce the bench.
Okay, good morning once again. I want to take this opportunity to welcome you now to the real business of the day. Seated with me, Bernard Kasavuli. On my right is Mheshimiwa Njagi, and on my left is Mheshimiwa Caroline Mugo. So you are free to, we all know the rules of engagement on how you will address the court. Feel comfortable. Let nothing make you feel like you want to panic. We are in a friendly mode, so we wish you success as you begin. So the court assistant, you can call out that matter.
Today's matter is Nyota Refugee Coalition and another versus Minister for Homeland Security and another. You may introduce yourselves to court. You can have the applicants to begin.
Good morning. I am Darshini Chavda, appearing as lead counsel for the applicants. I'm together with my team, who will then introduce themselves.
Good morning. My name is Salma Bashir, appearing as the second lead for the petitioners.
Good morning. I'm Trevor Hannington. I'll be assisting this team as a researcher. Yes. My apologies. We are team SC004.
Presiding Judge, good morning. My name is Ayaga Max Liambila, lead counsel for the respondents and team 001.
Good morning. My name is Joy Mweke, second counsel for the respondents.
Good morning. My name is Kelvin Nyaribo, third counsel for the respondent.
May it please the court, I am Darshini Chavda, appearing as lead counsel for the appellants in this case, along with my co-counsel Salma Bashir.
Just spell your name.
D-A-R-S-H-N-I and then C-H-A-V-D-A. C-H-A-V-D-A.
Just one line, Salma.
Oh, okay. I will use 10 minutes to dispense with the first and second issues, while my co-counsel will use the next 10 minutes to dispense with the third and fourth issues. We will take the remaining 5 minutes for rebuttals. Unless the bench has any questions, I wish to proceed with my submissions.
Yes, proceed.
The appellants will begin by addressing the first issue on whether the reliance on artificial intelligence in determining refugee status infringes fundamental human rights and freedoms. I will then move on to the second issue, which examines whether the principle of non-refoulement would be violated if Warido and his family were to be deported. An AI system was used to flag Warrido and his family as high-risk factors. The appellants argue that this system is unconstitutional and violates domestic and international standards. It lacks transparency, human oversight, and accountability, making it incompatible with the requirements of fair administrative and judicial processes. This system functions like a black box, where its outcome is given, however, the reasoning behind it is not given. This contradicts with Article 47 of the Constitution that guarantees fairness and gives reason for the decisions that are being made, which guarantees a lawful, reasonable, and procedurally fair administrative action. Under the Fair Administrative Action Act, Section 4.3 and 6.2 require administrators to give notice, disclose reasons, and allow affected persons to challenge these decisions. The system failed to meet these duties as the applicants were, like Warrido, were never informed of the evidence or reason behind their flagging. The denial of disclosure and participation contravenes with procedural fairness under this Act. Refugee determinations are very sensitive. They require empathy, credibility assessment, and humanitarian judgment. Yet, this system operates without meaningful human oversight. These uniquely human faculties cannot be automated, nor can AI alone determine what is reasonable or what is procedurally fair in such sensitive situations. Odi alteram partem translates to the right to be heard, a principle that has been incorporated under Article 50 of the Constitution that simply guarantees a fair hearing before an impartial tribunal. This right was denied when This right was denied to Warrido when the DRS delegated the refugee determinations to an algorithm. The failure to notify him prior to flagging under Article 47(1) and Section 3 of the Fair Administrative Action Act rendered the process constitutionally unfair. A refugee determination profoundly affects one's life and dignity. When such decisions are entrusted to a mechanical process, it strips them of compassion and fairness. This disregard for the human element undermines the constitutional values of dignity, justice, and procedural fairness under Article 47 and 50. The 1951 Convention and 1969 OAU Convention require fair, individualized, and transparent procedures. The opaque nature of this AI system contradicts with these principles and erodes the humanitarian objectives of international refugee protections. The appellants therefore request that the court declare the use of the AI system unconstitutional. They further seek an order that refugee determinations be conducted through transparent, human-led processes consistent with Article 47 and 50 of the Constitution and international refugee laws. Moving on to the second issue. The principle of non-refoulement simply prohibits refugees to return to territories where their life or freedom is threatened. This is shown under Article 33(1) of the 1951 Refugee Convention. Section 29 of the Refugees Act domesticates this principle, while Article 2(3) of the OAU Convention extends it to broader persecution contexts. Under Article 2(5) and 2(6) of the Constitution, these protections form part of NYOTA's constitutional guarantees. This absolute protection cannot be overridden by national security, as demonstrated under the case of Kitu versus Attorney General, where the Kenyan court declared that refugees cannot be deported to danger even if it's based on national security grounds. In the case of Hirsi Jama versus Italy, the European Court of Human Rights ruled that returning asylum seekers to Libya breached non-refoulement. As you can see, these authorities reflect the same case that is before us today. Although Article 33(2) of the 1951 Convention provides an exception where there are reasonable grounds to believe an individual poses real danger to security, it still cannot be used to justify harm or torture. Deportation to torture is never lawful, even when relying on security reasons, as explained in Suresh versus Canada. Fundamental human rights are breached when returning someone to face inhuman treatment, as stated in Soring versus United Kingdom. These authorities show the absolute nature of this protection. The AI system made unilateral determinations without human oversight or the right to appeal, which breaches Articles 47 and 50 of the Constitution. The applicants were denied the chance to challenge the evidence or reasoning, making the process procedurally defective. Hence, invoking national security in this context lacks procedural and substantive validity. The ongoing persecution in Zephyria is proved by the UNHCR reports along with other bodies. It includes detention, sexual violence, and execution of the opposition members. Warido's family is known to this Democratic Liberation Party, which puts him in the category and forces him to face an individualized and direct threat. Under Soring versus UK, this meets the real risk threshold, making deportation unlawful. Life and freedom are protected from torture under Articles 6 and 7 of the ICCPR. Article 3 of the CAT prohibits removal to states where torture is probable. Deporting Warido's family would breach these obligations and violate the constitutional duty under Article 2.5 to uphold international law. This principle is part of customary international law, according to the UNHCR Advisory Opinion of 2007, and is widely recognized as a jus cogens norm. It means no state can derogate from it or any act or refoulement automatically incurs international responsibility regardless of the domestic justification. Lastly, the AI process provided neither individual review nor an appeal mechanism, which violates the Constitution under Articles 47 and 50 and the UDHR under Article 8. Unless the bench has any questions, I wish to cede the floor to my co-counsel.
Very well. The bench will pose questions at the end.
Thank you.
May it please the Honorable Court, my name is Salma Bashir, appearing as the second lead counsel for the appellants. I'll be addressing issues...
Just a minute. Your surname?
Bashir.
Bashir.
Yes.
Can proceed.
I'd like to proceed if it pleases the court. I'll be dealing with issues 3 and issues 4. Issue 3 concerns the failure to conduct a best interest of the child determination prior to the deportation and detention of Warido's children. The appellants respectfully submit that the respondents violated Article 53, Sub-Article 2 of the Constitution by failing to conduct that best interest of the child assessment before they deported and detained Warido's 3 children. Article 53 of the Constitution provides that a child's best interests are of paramount importance in every matter concerning the child. This is also mirrored in Article 3, Sub-Article 1 of the United Nations Conventions on the Right of the Child and Article 4 of the African Charter on the Rights and Welfare of the Child. Both of these, under Article 2, Sub-Article 6 of the Constitution, form part of the Nyota domestic law. Therefore, the state's duty is to prioritize a child's welfare. It is not optional, it is constitutional. In Rono v. Rono and another 205, which is a succession dispute case dealing with gender, the Court of Appeal underscored that the best interest of the child is superior to cultural, political, or administrative convenience. Furthermore, in Mitu Bell Welfare Society v. Kenya Airports Authority, the case of 2021, the Supreme Court reaffirmed that dignity and equality must guide all state actions, especially where the vulnerable are concerned. My lord and my ladies, the records show that the respondents relied exclusively on an artificial intelligence refugee status determination system to categorize Warido's family as high risk. There was no human oversight, there was no welfare inquiry, and no individualized risk assessment for the children. This AI system was designed for data analysis, and it cannot perceive vulnerability, trauma, or the emotional context of this so-called displacement. By outsourcing judgment to an algorithm, the state abdicated its constitutional duty under Article 53, Sub-Article 2. And the deportation and the detention of Warido's children without that best interest of the child assessment contravened the Constitution, the Refugees Act, and international conventions binding on Nyota. This honorable court has the opportunity to affirm that no matter how advanced this algorithm is, it cannot replace human empathy where children's lives are at stake. I'll be moving on to issue 4, which deals with the incumbent order, human dignity, equality, and freedom of movement. The appellants submit that the incumbent directive and the continued holding of Warido and his family at the Nyairo Refugee Center violate 3 important key rights. The first one I'll be dealing with is the violation of human dignity, which is under Article 28. Article 28 states that every person has inherent dignity and the right to have that dignity respected and protected. The Nyairo Center, as reported by the UNHCR, is overcrowded, unsanitary, and unsuitable for children. In the case of MOOT Bell Welfare Society vs. Kenya Airports Authority, case of 2021, the Supreme Court held that dignity is the foundation of all rights and that any state action that degrades the dignity is binding and is unconstitutional. Refugees, my ladies and my lord, are not objects of charity. The human beings entitled to dignity under both our Constitution and under Article 5 of the 1951 Refugee Convention, which guarantees fundamental rights to all the refugees. Secondly, I'll be dealing with the violation of equality, which is under Article 27. Article 27 guarantees that every person is equal before the law and they each have the right to equal protection and equal benefit of the law. The incumbent order targeted only the Zephyrian refugees, branding them collectively as security threats. In the case of Law Society of Kenya versus Attorney General, in the case of 2017, the High Court stated that the equality is not merely formal but also substantive. It requires protecting the vulnerable from unfair discrimination. And by isolating these refugees based on nationality, the state violated both the letter and the spirit of Article 27. Lastly, I'll be dealing with violation of freedom of movement, which is under Article 39. Article 39, sub-Article 1, provides that every person has the right to move freely and to reside anywhere within Nyota. Any limitation of this right must satisfy Article 24, which requires that the restriction, if there need be reasonable, justifiable, and the least restrictive means to achieve a legitimate aim. My lord and my ladies, a blanket encampment order without individualized assessment or evidence of necessity fails the OAK test of proportionality, which requires that the measure, number 1, pursue a pressing objective, and number 2, impair rights minimally. In the case of Kituo cha Sheria versus Attorney General, the case of 2013, the court declared that forced relocation of refugees to camps are unconstitutional, holding that security cannot justify collective confinement. My lord and my ladies, issue 3 and 4 reveal one truth, that the true test of a constitution is how it protects those with no power, those with no citizenship, and those with no voice. The children of Warido deserved compassion, not computation. That the true test of a constitution is how it protects those without power, and how the refugees at Nyairo deserve dignity and not degradation. We therefore respectfully pray that this honorable court allows the petition, uphold the High Court's judgment, and reaffirm the constitutional rights do not end where fear begins. May it please the court.
Just a minute for guidance on your part. I hope you have organized yourself in a manner that the bench will know it's only 2 who have argued for the appellant and not the 3 of you. Okay.
May it please the court, presiding judge, honorable members of the bench. My name is Ayaga Max Liambila for the appellants. for the respondents, alongside Ms. Joy Mweke and Mr. Kelvin Nyaribo. If it pleases the court, I will spend the first 8 minutes to respond on the merits of the first and second grounds of appeal concerning the use of AI.
Just a minute. Yes, you can proceed.
Much obliged, my lord. If it pleases the court, I will spend the first 8 minutes to address the court and respond on the merits of the first and second grounds of appeal concerning artificial intelligence and non-refoulement. Ms. Mweke will spend 6 minutes to respond on the third ground of appeal concerning the best interests of a child assessment, and Mr. Nyaribo will submit on the last issue concerning the encampment order and the detention, and finally give our prayers of reliefs. If that suffices as the outline, I beg to proceed.
Yes, you can proceed.
My lord, my ladies, the appellants have painted a picture of a respondent who has traded justice for expedience. In the foregoing arguments, I seek to debunk these assertions and paint a picture of a respondent who has exercised its lawful mandate responsibly and in public interest. We shall demonstrate that the arguments by the appellants are not weighty enough to warrant the setting aside of the Court of Appeal decision in this matter, which pronounced itself on the constitutionality of the respondent's actions. I now turn to the first issue concerning the use of artificial intelligence in refugee status determination. The respondents contend that the use of AI in refugee status determination is consistent with the Constitution and international law. The appellant's case can be summarized in 3 main limbs. First, the violation of the right to fair administrative action under Article 47. Second, the violation of the right to a fair hearing. And finally, the compatibility with international refugee law. I'll start with the fair administrative action right under Article 47. Article 47 provides that every person is guaranteed the right to a fair administrative action that is lawful, reasonable, and procedurally fair. This very court, the Court of Appeal, in Suchan Investment Limited versus the Ministry of Heritage and Culture in 2016, established a test on what amounts to lawfulness. The Court of Appeal was of the view that an administrative action is lawful when 1, it's grounded in law, 2, within the scope of authority, and 3, consistent with the Constitution. I will demonstrate that the AIRSD is consistent with this test of lawfulness. First, it is grounded in law in that Section 7 and Section 8 of the Refugees Act permit the adoption of administrative processes by the Department of Refugees and the Commission of Refugees that are necessary for refugee status determination and management of refugees. Secondly, the United Nations High Commission of Refugees, in its digital transformation strategy of 2022-2026, and even more recently, in its communication on the approach of AI in September 2025, noted that AI may be used in refugee status determination provided that there exists review mechanisms that may be able to correct the decision that has been rendered by the AI. It follows, therefore, that the decision to use AI is grounded in statutory authority under the Refugees Act and endorsed by the United Nations Regulatory Authority of Refugees, which is the UNHCR. In the present case, if the court turns with me to paragraph 8 of the record, you will note that there is an appellate review mechanism of any decision that is arrived at by the AI. Now, contrary to the appellant's submission, there is indeed an opportunity before, first of all, an administrative tribunal, and secondly, before the High Court. In any event, whether appellants, aggrieved by that decision and did not wish to pursue these specific avenues, the High Court still retains supervisory authority over the decision that has been arrived at by the Department of Refugees. Turning to the question of compliance with the Constitution, which connotes the question of accountability under Article 10 as a national value, we submit that the same is not violated. The test of accountability in the use of AI is endorsed by the UNESCO's recommendations of 2021 on the ethics of AI, which means that decisions made or assisted by AI must be able to be traced to an identifiable institution, to be explained, to be challenged, or to be audited. What can be denoted from that specific definition are four-part tests. First is traceability, second is explainability, third is responsibility, and fourth is auditability. In the present case, the AI decision can be traced to the Department of Refugees. And you will not even, it's not the AI that is deporting Mr. Warido. It is not even the AI that is making the decision to deport Mr. Warido. If you look at paragraph 9, the AI stops at profiling Mr. Warido, what will normally be done by a human system in what will be referred to as background checks. Mr. Warido is profiled. Now, contrary to what the appellants have submitted, there are reasons for that profiling, and that is in paragraph 9. And it reads, if I may read verbatim, the AI RSD system flagged the family's asylum request as high risk because of their digital footprint allegedly linking Warido and his family to the DLP. And this can equally be again explained in paragraph 3 on what is the grounding of the DLP. It is a designated opposition party. Therefore, this decision by the AI can be traced, it can be explained, and equally, it can be reviewed before a tribunal and before the High Court. The test of accountability is therefore met. On the question of reasonableness, we submit that it is equally reasonable. And the test of reasonableness has been affirmed by this very court in Kandiye versus Alassani BA at paragraph 77. And this court, the Supreme Court, notes that the test is not a mechanical test, but is one of a case-by-case basis. We have to look at whether we can balance the decision to public interest. We submit that in this instance, we can balance the decision by reducing the delay that will normally accrue from a human assessment that will take weeks and a real-time assessment that will take very few minutes. The background check will normally take so many weeks, but in this case, the background check has taken very few minutes. If I may conclude that argument and finally move to the question of the right to a fair hearing. And I guide this court to the Court of Appeal decision in JSC versus Mbalo Mutava. And my lord, my ladies, the Court of Appeal was of the view that Article 50 and the trial guarantees under Article 50 cannot be mechanically applied to administrative actions. It follows, therefore, that refugee status determination is an administrative process. It is not a trial before a quasi-judicial or a judicial organ. It is an administrative process, and therefore it's guided by Article 47. And what this court will be looking at is the procedural fairness of the decision. And we equally submit it is fair because there are reasons given to the same, and equally the framework provides for recourse for appeal. Seeing that my time is much spent on the first issue, I conclude by saying this. Now, contrary to the appellant submissions as regards to international refugee law, in fact, international refugee law does not provide specifically on whether AI should not be used or should be used. The 1951 convention was adopted when nobody actually, in fact, thought about the AI. But the United Nations High Commissioner for Refugees has endorsed the use of AI. And therefore, it cannot be that the regulatory authority of international refugee law endorses a certain use and the appellant said the same is not endorsed. Turning to my final argument on the second ground of appeal, on the deportation of Mr. Warido, the respondents contend that the deportation of Mr. Warido was in line with the exception to the principle of non-refoulement. And secondly, the decision to deport was consistent with the balancing of the state's interest in this instance. Article 33.2 of the 1951 Convention, Article 23 of the OAU Convention of 1969, and Section 29.4 of the Refugees Act permit the refoulement of a person who is a threat to the national security. The same case law that the appellants has referred to, Suresh versus Canada, at paragraph 169, the court affirms that a person may be refouled on grounds of national security. Therefore, that case is much in favor of the respondent's argument as compared to the appellant's position. Honorable members of the bench, if you move to the record and look at paragraph 11, Mr. Orido is deported on grounds of national security. Look at paragraph 3. Mr. Orido is affiliated. And I would like that this court goes into the definition of what affiliation means. Affiliation is not a mere linkage, but rather it means formal implication to a specific organization. And I therefore submit that it was in line with the state's interest to refoul Mr. Orido, since they are a threat to the national security interest of the state. And this position has been affirmed twice by the United Nations High Commission of Refugees in its notes on exclusion clauses and its notes on international protection. With that, my lord, my ladies, I conclude the respondents' arguments on the first and second grounds of appeal and pray that this court makes a finding in favor of the respondents and upholds the decision of the Court of Appeal. I now invite Ms. Mweke to submit on the third ground of appeal on the best interest of a child assessment. Much obliged, my lord.
May it please the court, presiding judge, distinguished members of the bench, my name is Joy Mweke and I appear as second counsel for the respondents. In the next 6 minutes, I will raise responses to the claims put forth by the appellant regarding the third ground of appeal on the best interests of the child. We contend that the Court of Appeal rightly found the respondents not to be in violation of the Constitution and their international obligations. My lord and my ladies, this case is not about denying the importance of the best interests of the child. It is about the difficult balance between compassion and caution. It is about a state which acted not out of indifference, but out of a duty to protect the safety of our nation at a time where its security was threatened. We respond in two limbs. First, by showing that our actions prioritize the preservation of the family unit, then by demonstrating that the rights of Orido's children were rightly limited. On the preservation of the family, Article 53(1)(e) of the Constitution guarantees every child the right to parental care and protection. Article 9(1) of the Convention on the Rights of the Child further prohibits the separation of the child from their parents unless it is judicially determined to be in their best interest. Furthermore, we take cognizance of paragraph 5 of the preamble of the Convention on the Rights of the Child, which recognizes the family as the natural environment for the growth and well-being of its members, particularly the children. But even jurisprudentially, the Constitutional Court of South Africa, in S versus M, decided in 2007, has underscored the importance of preserving the family unit. And in paragraph 20 of its judgment, the court highlighted that the best interest of the child requires best efforts to avoid, where possible, any breakdown of the family life or parental care which may threaten or put the children at increased risk. My Lord and my ladies, you will note that all through the detention and even at the point of issuing the deportation order, the children were not separated from their parents. This demonstrates our commitment to safeguard the welfare of Orido's children who are in a new environment, needing their parents by their side. Turning to the second limb on the limitation of the rights, as rightly noted by the appellant, Article 53(2) of the Constitution recognizes that the best interest of the child shall be of paramount importance in every matter concerning the child. Even so, the Committee on the Rights of the Child, in its general comment number 14, pertaining on the right of the child to have their best interest taken as a primary consideration, notes in paragraph 6 that this is a substantive right, but not an absolute one. This then means that this right can be qualified. And this has also been affirmed in Refugee Consortium of Kenya and another versus the Attorney General and two others, decided in 2015, where the High Court stated that the best interests of the child are not an absolute bar to implementing legitimate national security concerns and refugee control measures. The burden on our part therefore becomes to demonstrate the legitimacy of our national security concerns. It is clear from paragraph 9 of the record that the deportation order followed the finding of the AIRSD, which had flagged the family as high risk because of their affiliation to the Democratic Liberation Party, a designated terrorist organization. Our actions also align with the findings of the Committee on the Rights of the Child in its general comment number 6 of 2005, which permits for the return of children to their home country in situations where they constitute a serious risk to the security of the state. Now, the appellant have submitted to the extent that we relied only on the accuracy of the AIRSD. However, the burden placed on the state is to back their decision with evidence. And as found, or rather as held by the Court of Appeal, the AIRSD was accurate in its consideration. Beyond that, my lord and ladies, Nyota has been subjected to 4 coordinated terrorist attacks. Now, we don't seek to rely on this to link the family to these attacks. However, we seek to demonstrate that such claims associating the family to a terrorist organization justify the gravity of the matter, as well as the urgency of the state to preserve its national security. Our actions, in conclusion, also conform with the parameters of Article 24 of the Constitution, requiring the limitation of the rights to be legal, necessary, and proportionate. On legality, Article 19(1) of the Refugee Act permits the expulsion of refugees and members of their family if they pose a threat to the national security. On necessity, as I have demonstrated, it was urgent for the state to take necessary protective measures. Further, on proportionality, and as held by this court in Kandie versus Alassane BA and another, the limitation of rights requires a balancing test. As seen in paragraph 9 of the fact pattern, the family was not flagged simply as a risk to the security of the state. They were flagged as a high risk. This then called for measures of equal weight to combat the security threat and safeguard the country. My lord and my ladies, as I conclude, there comes a time where those entrusted with the safety of many must act not out of desire, but out of a duty. And today we ask this court to see that duty for what it was, a necessary act of proportion and not a punishment. We therefore invite this court to uphold the finding of the Court of Appeal, finding the respondents not to be in violation of the Constitution and their international obligations. I now cede floor to my co-counsel.
May it please the court. My name is Kelvin Nyaribo, and I seek to address the responses that the respondents offer as regards to the fourth issue on the encampment order and the holding of Warido and his family at the Nyairo Center. Presiding Judge, honorable members of the bench, we approach this court mindful of the gravity of the rights that have been invoked by the appellants in this matter. However, we are also cognizant of our solemn duty to, as a state, to safeguard the paramount responsibilities of safeguarding human rights, but at the same time, national security. We therefore request this court to navigate that delicate balance where the law must hold both in a careful balance. I will now turn your attention to the fourth ground of appeal. The respondents contend that the Court of Appeal rightfully held that the High Court erred in holding that the encampment order and the holding of Warido and his family violated the Constitution. We argue that first, the encampment order was a justifiable and reasonable security measure. Second, the temporary holding of Warido and his family did not violate the Constitution. On the encampment order, we acknowledge that under Article 26 of the Refugee Convention, refugees have the freedom of movement and residence. However, this right is not absolute and therefore can be limited, and we rely on this court's decision in Kandie versus Alassane Ba and another in 2017 at paragraph 78, that we need to demonstrate that we've adhered to the test in Article 24, that is the reasonable and justifiable test, which is pegged on ensuring that it is on the parameters of legality, necessity, and proportionality. And looking at Article 24.3 of the Constitution, the onus is on us to demonstrate that we meet this test conjunctively. I will begin with the question of legality. Pursuant to Article 12.3 of the International Covenant on Civil and Political Rights, it permits the restriction of the freedom of movement and residence if lawful and necessary to protect national security, and it is proportionate to the sought aim. We refer the bench to paragraph 12 of the facts. The respondent relies on the national security concern because there were 4 coordinated terrorist attacks that posed a threat to life to not only its citizens, but also the innocent refugees. That is the national security that we rely on. And this court's holding in Haki na Sheria initiative versus Inspector of Police and 2 others in 2023 acknowledged why we have derogation clauses, and that in exceptional times it can be crucial to curtail rights in order to preserve their long-term existence. In this case, the terrorist attacks threatened even enjoyment of other rights. Turning to the question of necessity, we submit that the encampment order was the most, or rather, it was as a result of the unfortunate 4 terrorist attacks. And there was need on the part of the government to ensure national security is maintained and the lives that were at stake are not violated. It was necessary to forestall the further attacks, and considering the nature of terrorism, as you acknowledge still in that Haki na Sheria initiative case, it is of an international nature. The threat requires a multinational and multi-agency approach, and that denotes the need for the state to act appropriately. Therefore, it was necessary to allow the encampment order to contain the threat. Lastly, on the question of proportionality, the appellant submitted that this encampment order was disproportionate. However, we submit it was the most appropriate and effective measure that would help contain the threat. This is because we were not treating the symptoms. We were treating the disease, the root cause of the problem. Turning your attention to paragraph 12 of the record, the 4 terrorist attacks have been attributed to foreign elements taking advantage and exploiting the refugee mobility. It was this, the root cause of the problem that we addressed by making an order that the refugees move to the camps within 10 days. They cited the decision in the Court of Appeal in Attorney General versus Kituo cha Sheria and 7 others. That same decision, and this is distinguishable from this case, the encampment order was invalidated because it was speculative and evidentially unsound. Contrarily, in this case, there is evidence to prove that the foreign elements took advantage of the refugee mobility, as is evident under paragraph 12 of the record. Additionally, we argue that this was a precautionary step, and this court has appreciated the same under paragraph 46 of the Haki na Sharia case, that a precautionary principle is important because it is designed to prevent potential risks, and it is the duty of the state to ensure that they enact protective measures so that they don't wait for the risk to manifest. So they are ready for terrorist attacks, and we do not want to risk the lives of our people. So it was therefore necessary, and it was a proportionate decision. And unlike in the Kituo cha Sheria case, where the order was immediate and people were arrested, here we gave them 10 days to allow smooth and humane transition to the camps. On the second limb, on the holding of Warido and his family, we submit that this was a temporary action, and it does not violate the Constitution. The reason why Warido and his family were detained was because they were flagged as high risk due to their affiliation with a terrorist organization. A responsible state cannot take the risk of releasing individuals who have been designated as high risk because they have a responsibility under Article 238 of the Constitution to ensure and protect the national security of the state. Relying on the Kituo cha Sheria case at paragraph 85, it acknowledged that the state responsibility of national security, and that courts must accord state difference and a margin of appreciation in the exercise of this responsibility. Additionally, we acknowledge that the detention center have been documented to be overcrowded and sanitary, and that is the position that was held by the appellants. But we wish the court to appreciate that this was as a result of logistical pressure. This is because we are told under the fact that there was a mass influx of thousands of refugees, or rather thousands of refugees from Zephyria, and therefore our facilities were strained, and that is the reason why there happened to be unsanitary conditions, and that our rooms, or rather our facilities, were overcrowded, and we wish that the court appreciates that. Therefore, in conclusion, and in the overall submission that have been made by the respondents, we ask that this court upholds the Court of Appeal decision and finds that this appeal lacks merit and that the respondent acted within the bounds of the law. I will now yield the floor back to the court for further directions.
Okay, thank you so much to both the teams. Before we give the appellants a room for rejoinder, we will want to seek for some clarifications from the teams. I will allow my colleagues here if they have any clarification, and then I wind up on it. So to just a few issues. Maybe I start from where we have just stopped. Councillor Nyaribo, in your submissions you have justified the actions of the state actors in the manner in which they handled Warido and the family. That tag of foreign elements, how do you align that tagging in terms of the suitability test, the justifiable standards, in terms of what the state actors took against Warido's family, which the appellants contend that it was an infringement of their rights. To Mweke, the best interest of the child standard, according to your argument, you justify what happened, if I understood you right, for the reason that the children were not separated from their parents. They were kept closer to them. So maybe in terms of Article 53 of the Constitution, are you suggesting there is an exemption to the applicability of that Article 53? Maybe just a clarification on that. To Ayaga, on the use of AI, do you have any authority on domestic legislations and the protocols which maybe the state relied on in doing what they did? Then on the issue of refoulement, the Refugee Convention provides for the exceptional clauses. Do the facts of this case fit in the exemptional clauses? Maybe if you address that, I will be comfortable with it. A minute, just a minute. For the appellants, I cancel Bashir. What evidence did Warid give to demonstrate a well-founded fear of persecution? And how does that evidence meet the objective and subjective components of the well-founded fear standard? A minute again, unless I am done. Yes, Bashir, this is also directed to you. In terms of the use of AI vis-a-vis the Data Protection Act, is there any relationship in terms of the use of it, the protocols available under the under that legislation, especially the Data Protection Act? And to your colleague, the first counsel who spoke for the appellants, what domestic legislation on AI would you want the court to bear in mind in your challenge of the decision by the state in terms of what they did? So I think on my part, that should be enough if addressed.
Thank you so much for the teams and for your presentations. I just have one question for the respondents. Because as Council Nyaribo said, at the end of each presentation, he kept saying that the AI highlighted these people because they were a high risk, because that's the thing I've been hearing from all the teams, the high risk, the high risk. But now, looking at if there's any current legislation, do we consider that they were political refugees? is that aspect of looking at the fact that they were being hunted politically from their side, avoiding the fact that they were already high risk, but they were political refugees. Do we have any authorities or any laws that cover that cluster of people, if you're aware of that, either internationally or domestically here in Kenya, or even regionally within our continent? Do we have anything like that? Do they fall within a special category that you're aware of that can then be sought out to be protected specifically because they fall within that special category? Thank you.
So when we are done, we will start with the respondents. You answer. Then we finish with the appellants. After you are done, then you can tackle your right of rejoinder.
Okay, thank you so much for the very insightful presentation. I think my colleagues have basically tackled what I needed clarified. I only have one issue which I would want the appellants to respond to. You can choose between the two councils who presented, who will tackle that. I know that you have relied on two decisions, one being the decision of Suresh versus Canada, and also Kituo cha Sheria, which I think the respondents have said are distinguishable to this case, and have said they actually favor the respondent's case. So maybe you can just clarify, since your authorities have been attacked, whether it's true they are distinguishable in this particular case, and if in fact they do favor the respondent and not the appellant.
Yes, you are free to give your clarifications now.
Presiding Judge, if we may start with your question as regards to any authority or domestic legislation which may have been relied by the state. Now, at the moment, there exists no domestic legislation specifically in reference to the use of AI in refugee status determination. However, first, for clarity, if you look at the United Nations High Commission of Refugees Digital Transformation Strategy of 2022-2026, it seeks to resolve the gaps that existed between the time of the adoption of the convention, which was slightly almost 70 years ago, until now. There exists delay, there exists backlog, there exists incoherence. In this instance, it endorses the use of AI under specific conditions. And one of those conditions is that there should exist a procedure for reviewing the decision of the AI. And we are aligning with that position by providing not one, but two review mechanisms of that decision. In the event that the appellants may feel that the decision by the AI is erroneous, they may appeal before the tribunal and equally before the High Court subsequently. You will also note that the draft African Union draft strategy of draft continental strategy, that is for Africa of 2022, equally endorses the use of AI to solve the gaps that existed. And even more recently, the United Nations High Commissioner for Refugees AI approach. And if I may show state practice in reference to the same, you will note that the UNHCR itself is using Project Jetson, which is an AI tool that is currently using for to check refugee data and analyze refugee data. If you also look at Australia, Border Point uses AI to look at the background check and profiling, and it equally has a review mechanism. So the AI RSD reflects the best practices the same. In response to the question of whether the facts in this case, and maybe just to tie to the question of Justice Njagi on whether the AI highlights, and we've been relying on the AI in most of these decisions, and secondly on the question of political refugees. First, the AI does the profiling, it does the background check. And the reason why we are all relying on the AI is that the facts in this case are supporting the decision by the AI. If you look at paragraph 3 of the record, the AI is finding exactly what we knew. It's not finding something different. And if the same was incoherent, then we'll flag that. But it's just supporting what we already know. On the question of political refugees, the 1951 Convention and the 1969 OAU Convention, both of them protect people who flee from their states or habitual residents because of persecution based on political grounds. And we do take the court's concern as regards to the fact that they are flown from the state of Liberia because of political grounds. However, all political refugees are not exempted from exceptional clauses under Article 1951. And even the Suresh case that the appellant is relying on, Mr. Suresh was accused of affiliation to a Sri Lankan opposition party that had then been designated as an opposition party. So, if this court is to set a precedent that all political refugees, despite the fact that they may be a threat to our national security, cannot be refouled, it will be opening a floodgate to all political refugees, even those who are affiliated to designated terrorist organization. And equally, guiding this court to a more persuasive jurisprudence in Swaring versus Canada versus the UK, which was elaborated again in Chahal versus the UK, the same jurisprudence that the appellant has relied on. The court was of the view that even despite the fact, and in all those cases, Mr. Chahal, Mr. Swaring, all of them were political refugees, but the court was of the view that national security should be considered. And yes, my lord, while there are exceptional clauses in Article 33.2 specifically, this case, the facts in this case meet that test because they are affiliated. It's not just implication. And that's why we are differentiating from the case, the Kituo cha Sheria case. It was just a blanket assumption that because you relate to a certain tribe, then you are designated terrorist. In this case, they're affiliated. And that is why I call this court to look at the definition of affiliation. It has not been used in this record just for the sake of it. It's specifically above being linked to a designated terrorist organization. With that, I now cede floor to colleague to respond.
Presiding Judge, my ladies, I rise to respond to the question posed to me by Justice Kasavuli concerning whether there is an exemption to the applicability of Article 53. And in response, we rely on this court's decision in CMM versus Standard Media, which recognized that the best interest of the child is a substantive right. To that end, the question now becomes, can this right be limited? And we contend that the rights under Article 53 don't form the list of non-derogable rights listed under Article 25, meaning they can be qualified under Article 24 of the Constitution. And while the Constitution under Article 53(2) calls for the paramount importance of the best interest of the child, that has been interpreted by this court to mean that it has to be given the highest consideration, not the only consideration. To that extent, we cannot neglect the fact that you have to also consider other considerations that must be weighed against the competing considerations. And we further relied on Refugee Consortium of Kenya and another versus the Attorney General, which clearly stated that the best interest of the child cannot be an absolute bar to implementing legitimate national security concerns. So in conclusion, the respondent is asking this court to strike a balance between the interests of the children and the legitimate national security concerns. Much obliged.
May it please the court, I'll respond to the question posed to me by Justice Kasavuli on the linkage vis-a-vis the foreign elements and the Warido family. First of all, to clarify, the foreign elements are taking advantage of the refugee mobility in terms of paragraph 12 on the terrorist attacks. The Warido family is being detained on the basis of them being assessed as high risk due to their affiliation with a designated terrorist organization. But to respond to the question on then suitability versus justifiability, we rely on this court's decision in Kandie versus Alassane at paragraph 77 that what is reasonable and justifiable is not a mechanical list, and therefore the court is called upon to examine on a case-to-case basis the facts. So the facts of this case were, it was urgent because there were already 4 terrorist attacks that pose a threat to life. And it was urgent and necessary to take a measure that will help contain the threat as the state now takes individualized investigations to identify the foreign elements. I yield the floor back to the court.
Thank you for your questions, my lord and my ladyship. I will begin by first addressing the question on the domestic legislation for the AI system. AI currently is an emerging technology. Therefore, there are no past legislation on it. However, we can still rely on the Fair Administrative Actions Act, as the AI system itself is an administrative process, specifically under Article 47. Secondly, I would like to clear the misunderstandings that are brought about regarding the case laws, specifically of Suresh versus Canada and the Kitushasheri case. In Suresh versus Canada, at the end of it, the decision was held that Suresh was not deported back to his country, as it would violate his rights under Section 7 of the Canadian Charter of Rights and Freedoms. The deportation would also lead to go against Article 3 of the UN Convention Against Torture. As for the Kitushari case, it was held that the principle of non-refoulement was upheld, and it was held it was unconstitutional and unlawful. The principle of non-refoulement was violated, as it could result in refugees being indirectly returned to danger. Articles 28, 39, and 47 were also breached in this case, and it stated that the government cannot rely on national security as a justification to disregard binding international obligations towards refugees. If we refer to Article 10, Section 10 of the fact sheet, it provides the similar facts as to this case. Therefore, we can rely on these precedents of both cases as a matter of fact, and this is why the cases favor our side more than the respondents. Thank you.
My lord and my ladies, thank you so much for the questions. I will first start with the first question, whether there was any evidence that Warido gave to demonstrate fear. I'd like to direct the bench to paragraph 4 of the Statement of Facts, the last sentence where it says, on multiple occasions, Warido and his wife have been subjected to incommunicado, detention, and torture. I think it's merely common sense that if you have undergone something, which is the torture that they have undergone, you would also think and you also know that if you were to be sent back to where that had been done to you, then obviously you will have that fear to know that it can also be repeated. Secondly, I will go to the second question where it says if the similarities between the DPA and the AI that was used. I would not say there's a similarity. What I would say is that the DPA oversees the algorithm. And furthermore, the respondents have failed to show that I would like to direct the bench to paragraph 8 of the Statement of Act, where it says that this system had the capacity to conduct biometric analysis, social media history reviews, and behavioral patterns assessments to make real-time asylum decisions. The question is, where do these biometrics go? Where do all this data go to? Because for the DPA, at least it is protected and we know. But what do we know about this algorithm, and where are the data for the Warido's family taken? Yes, thank you.
You were to immediately after that exercise your right of rejoinder. You can proceed and do so.
May it please the court, I will now be addressing the questions that have risen from the respondent side. I will first begin by stating that the Fair Administrative Actions Act, Section 4 and Article 47 of the Constitution both explain what a fair administrative action should amount to. The respondents have effortlessly proven that the AI system is lawful. However, they have failed to show us that it does not meet the requirement of it being procedurally fair. For administrative action to be completely fulfilled and fair, it needs to meet all requirements, not just some. Secondly, Article 33(2) of the Convention was cited on refoulement and the exception of it based on national security and also if they're a criminal. Article 53 of the Vienna Convention on the Law of Treaties voids Article 33(2) as it is incompatible with the jus cogens norm of non-refoulement. Moving on, the right to appeal does not equivalent to a fair hearing. The appeal is based on a decision that is already made by the AI, and decisions after the appeal is going to be based on arguments based on the decision that was already stated. This does not give Warido or his family a chance to bring forward their case. An appeal is not the same as an initial hearing. Therefore, Article 50 of a fair hearing was breached. Lastly, you cannot trade one's freedom or life based on the element of time. Agreed that the AI is fast, but is it efficient? Is it reliable? As they stated, a background check could take 5 minutes or even a few days. However, is our priority looking at how fast a decision is made or how reliable it is being made? Because how can we make a decision at the cost of another one's life? Thank you. I will now cede the floor to my co-counsel to address the second part of the rebuttals.
May it please the court. I'd like to start with issue number 3, where the respondent stated that it was suitable for Warido's children to stay with their parents. But my question to the bench and to my respondents is, if I may direct the bench to paragraph number, yes, if I might direct the bench to paragraph number 10, the last statement where the UNHCR has founded the facility to be overcrowded, unsanitary, and unsuitable for children. So my question is, how can that child be safe when they have to endure that unsanitary place, overcrowded, and the UNHCR literally says that it is unsuitable for children? Moving on, I will tackle issue number 4, where the respondents refer to paragraph 12 of the facts following the 4 terrorist attacks. But my lord and my ladies, I'd like to refer you to the Kituo cha Sheria versus Attorney General, where the court declared that the forced relocation of refugees to camps unconstitutional. The respondents say that the case is not the same because of the attacks. But my lord and my ladies, the fact that it was the despotic Zafarian government that declared its own opposition a terrorist organization, mind you, after refusing to cede power despite evidence of malpractice, which I would like to direct you to paragraph number 3 of the statement of facts, where it says, after the May 2020 elections, the incumbent authoritarian president refused to cede power despite overwhelming evidence of electoral manipulation and widespread international condemnation. Thank you.
So we come to the end of this session. Thank you for the erudite submissions you have made so far. We will break so that we allow for another session to come in. The results, I hope you are informed, will be announced later in the day. when all teams are done. Otherwise, congratulations for the submissions you have made. So we break for another session.
Utoe memorials za the next team. Unaenda timu gani?
we want to be popular.
Check. My test. 1, 2. Check 1, 2. 1, 2. Mic test 1, 2. Check. Mic test 1, 2. Check 1, 2. 1, 2. Mic test 1, 2. Check 1, 2. 1, 2. How's bad I go? 1, 2. Check 1, 2. Basi fanya hivi. Check 1, 2. Okay, inua kila kitu parts plus nini inua.
Speaker nasikia kweli. Haya. The court derives its mandate from the Constitution and exercises the following jurisdiction. Yes? Now. Exclusive original jurisdiction under Article 163, 3A to hear and determine disputes relating to the elections of the office of the President. In exercise of this jurisdiction, the court must hear and determine such petitions within 14 days from the date of filing. Appellate jurisdiction under Article 163, 4A and B to hear and determine appeals from the Court of Appeal and any other court or tribunal as described by national legislation. Appeals from the Court of Appeal lie to the court of the Constitution, and upon certification by either the court or the Court of Appeal that a matter of general public Check. Sound. Okay, let's do this then. If history doesn't follow any stable rules, and if we cannot predict the future, why study it? Yeah? So, utaniambia. It often seems that the chief aim of science is to predict the future. Meteorologists are expected to forecast whether tomorrow will bring rain or sunshine. Economists should know whether devaluing the currency will avert or